Good morning, everybody. Thank you for joining today. Join us today for this week's weekly trade and tariff webinar. My name is Rich Israelson. I'm the Chief Revenue Officer at World Trade Center, Utah, and it's my pleasure today to be facilitating this conversation. If you're here for the first time, this is a weekly webinar series, and it's intended to provide you with the latest information about trade and tariffs, of which there is always more to talk about every Friday. And you can view previous webinars if there's something that you may have missed. You can view that on our YouTube channel and find updates to our tariff dashboard on our website, WTCutah.com. Today, we're excited to hear first from Ben Collender, who's the Chief of Staff at World Trade Center, Utah. And he's going to give some updates from that dashboard, which changes every day. And then we'll move on to the next part of our discussion. But Ben, take it away.
Thanks, Rich. And also shout out to my colleague Lena, who's probably watching and constantly helping with these updates in the background. So I'm going to share my screen really quick. So can everybody see the tariff dashboard? So as usual, just in case it's your first time here, we're just going to go through and remind everybody you can access these updates anytime on our website, wtcutah.com/tariffs, where there's also a link to register for these webinars. So if you ever want to share this with somebody who you may know who would benefit from this information and these regular updates, you can just share this page and let them know there's a link at the top of the page. Um, Today, we're going to dive into a few relevant updates and questions that have resulted from the Supreme Court case on tariffs. So, as many of you remember, the Supreme Court ruled that these IEEPA tariffs are not legal. And so there have been a lot of questions around, in particular, two topics. One is, what's the refund process? Is there going to be a refund process? Will refunds happen? And as many may recall, the Supreme Court intentionally left that a little bit vague and for lower courts to figure out. And the second question is around the trade deals. We're not going to touch on that too much today, but we're going to talk a little bit about some updates regarding the refund. So while it was actually day before yesterday, the Court of International Trade ordered that companies will receive refunds for this. So that was one of the big questions is, will we even get refunds? The answer is yes. The Court of International Trade said that should be ordered. Now, the second question really goes to, follow-on question, does it only apply to the companies who filed the lawsuits? And the court, the Judge Eaton said, whether or not you filed a lawsuit, you should be eligible for refunds. So it was a very broad mandate in terms of who should be eligible for refunds. So we're still waiting to see more details on this. I saw an article this morning that talked about how Customs is not issuing refunds yet. And to me, that's very clearly because they're still working out a process. So the fact that this made news is a little bit of a surprise. I will read a quick piece from an article I saw this morning, though, that outlined this. An attorney involved with other trade refund cases told Reuters they believe that a meeting, and this is a private meeting happening today with the Court of International Trades and International Trade and CBP, it will result in a process that will be made public as soon as today. So we anticipate likely hearing more about this later today. And the biggest piece of advice that we've had along the way for Utah companies is, hey, look out for fraud. Keep track of your receipts. These are things that are going to be important in the process when you go back to get your refunds and to make sure that you're actually getting, paying and doing the right things rather than clicking a link that's fraud. So keep an eye out for that. Make sure it's official resource or, official sources sending you information, having you back and forth. So another piece that we wanted to highlight for our attendees is the piece on critical minerals. So, as many may remember, 232s and 301s remain in place. The Supreme Court decision only focused on the IEEPA tariffs, which are broad, and there were so many of them. Our dashboard is so much cleaner since this decision, by the way. Um, but the 232s remain in place, particularly one that we're going to highlight with critical minerals. So this is important, especially for a lot of folks in Utah and a lot of companies in Utah. As many people know, we have a big critical minerals presence here. This is a critical minerals 232, and there's a federal register that is currently open seeking comment on a lot of policy and approach sort of questions about what the federal government can do, whether it's price floors, tariff rates, what that looks like. So you'll see on our dashboard this link right here. You can click it and it goes through the request for basically critical minerals and the 232 and what, trade agreements could look like, what different rates could look like. Um, so if you're in the space or know somebody in the space of critical minerals, I would encourage you to send that bit of information along. I know we do. We've shared it with our mining association, a few other folks as well. So um, the last thing I'm going to cover is uh, news for everyone. It's not new news. We talked about this last week, but the 122 tariff, just a little bit further in depth, and I know our colleagues here, Chase, is probably going to dive into this a little bit more, Maggie. But the 122 tariff that was put in place after the Supreme Court decision, that is in effect until right now. The timeline is 150 days. We're tracking July 24th for that tariff to end unless Congress takes action. So I'm sure Chase and Maggie are going to have some crystal ball advice here to talk about on that front. But this is something we're going to continue to monitor. But we are tracking the 150-day limit, which we haven't talked too much about. In addition, we talked about some exemptions in our last webinar. And just as a reminder, if you're wondering if your particular product is going to be tariffed or not, we have Annex 1 and Annex 2 of the executive order linked on our dashboard. So you could just go in there and say, okay, what are the exemptions? And we've got the full list along with the HTS codes here. So you could go back, compare that to what you're importing and see if your product is on the list or not. And so with that, I'm gonna pause, hand it back to Rich, and happy to answer any questions that come up.
Thank and again, um, just really, really proud of that dashboard that is maintained, and it is no small task to keep up on that. Um, we're going to pivot now and introduce Maggie Monday and Chase Dunn from Cassidy, Levy, and Kent. We really appreciate their time this morning and their expertise. And without further ado, I'll pass it over to Maggie and Chase.
Thanks, Rich. We're really excited to be here. I'm going to share my screen so that you guys can see this presentation that we've put together. Are you guys able to see this? Okay, great. So as Rich said, I'm Maggie Monday. I'm an associate at Cassidy Levy Kent in Washington, D.C. I'm joined by my colleague Chase Dunn. We're really excited to be here. We love World Trade Center Utah. You guys do great work. Your tariff dashboard is incredible. We reference it sometimes. So we're really excited to be here and talk to you guys about this kind of ever-changing situation. It seems like every day we get new updates, but hopefully we can brief you on where everything is right now and give you some guidance on where to go from here.
So I'm sure as everyone on the call knows, on February 20th, the Supreme Court held by a vote of 6-3 that IEEPA, the International Emergency Economic Powers Act, does not authorize the president to impose tariffs. I think, President Trump had imposed these tariffs to address, different national emergencies dealing with fentanyl, drug trafficking in the United States, and persistent trade deficits. These tariffs were imposed on almost all U.S. trading partners, and it generated well over $100 billion in revenue in the short period that they were actually in place. So the language on the slide we have here, and I know you guys have probably read a lot about this. We won't spend too much time on the actual court opinion, but we just wanted to kind of highlight maybe one or two interesting points of the opinion. The language on the screen here is really the heart of the matter. The court held that the terms regulate importation do not authorize the president to impose tariffs of any amount of unlimited duration on any trading partner at any time. So I want to just note kind of two or three different bases for this opinion, because the majority, although it was 6-3, they couldn't all agree on why or how they got there. And I think some of those distinctions are actually pretty important for future cases, maybe even future trade cases. So the first issue was really just statutory text, right? The statute, IEEPA, other statutes other than IEEPA, excuse me, that authorize the president to use tariffs, 232, 301, 122, they use explicitly the terms duties, tariffs, or taxes, right? Whereas IEEPA does not. Congress knows how to delegate tariff authority, and when it wants to, it does so very explicitly. And no president in the 50-year history of IEEPA has ever invoked IEEPA to authorize tariffs, which the court, in the Roberts opinion, found persuasive. The second prong of the opinion is really a constitutional structure argument. The Constitution grants Congress alone the taxing power, and if Congress wanted to, or if interpreting the term regulate allowed the executive to impose taxes or tariffs or duties, I think the court was very worried about what that would mean for other statutes that use that term. Congress passes a lot of statutes allowing various agencies or the executive branch generally to regulate certain activities, right? Securities, financial transactions, environmental issues. And so if the court were to hold that the term regulate can encompass the taxing power, which again is a core constitutional congressional power, I think there was some concern among the justices what that would mean or what doors it would open for future presidents to engage in tariffs or taxes or duties on a wide range of other economic or activity happening in the country. So I think the statutory text played a major role. The core constitutional structure argument seems to have been very persuasive for all six justices. There was a third prong, which only got the conservative justices. It's called the major questions doctrine. This is a Justice Gorsuch issue. He's been trying to build it and rebuild this particular issue. But the liberal justices did not sign on to that part of the opinion. They thought they could just focus on the text and the core constitutional structure and move on. The major questions doctrine really just holds that the courts are not going to presume that Congress is granting vast economic or political power to the executive unless Congress states explicitly that it's doing so. And again, here the terms regulate importation were seen as too broad and too ambiguous to kind of meet that threshold. So what's notable, and Ben touched on this though, is that the court opinion did not address refunds. Justice Kavanaugh in his dissent noted it was going to be a mess, and I think that's right. And it did not address the president's authority to impose tariffs under any other statute, right? This was an IEEPA specific decision. So I think, I'm happy to answer any questions. Us lawyers could talk about this opinion forever. It's a very interesting opinion. It's 170 pages. And so there's a lot to get into, but I think for now, I think that's probably sufficient, and we can move to the next slide.
Thanks, Chase. Yeah, it's interesting, and we could talk about it all day, but we won't we won't bore you with it. I think that one of my favorite things that I learned in law school is the original case that decided the major questions doctrine proposed that Congress was not going to hide elephants in mouse holes, and I think that that's a very fun phrase for anybody that cares about boring legal arguments. So just from a practical perspective, there's the administration effectively ended IEEPA on February 20th, and Customs issued its own set of instructions saying that IEEPA duties would not be collected after midnight on February 24th, 2026. So this is just to show that, it's over and done after February 24th, 2026. IEEPA duties will no longer be collected. Now, this doesn't address what happens to the IEEPA duties that have already been collected. So that's what Chase is going to elaborate on a little bit more.
So yeah, what's next? IEEPA refunds. I know this is of critical importance to everybody on the call, and so I want to spend a few minutes kind of walking through what we know and what we still don't know. And as a preview, there's still a lot that we do not know. But I think before I begin, I just want to back up a little bit and make sure that everyone understands what we mean by the term liquidation, because it's really important to understand that term, and it's going to determine the kinds of steps you need to take to preserve your rights for refunds. So liquidation is the term CBP uses to refer to the final determination of whatever duties, taxes, or fees are owed on an importation. That's all that term means. It usually takes about 300 days for an entry to liquidate, to kind of go through that process and determine the final duties or taxes owed. Could be a little bit earlier, could be a little bit later, but roughly it's about 300 days, right? So that's when we refer to an entry as an unliquidated entry, it's still in that 300-day period where duties have not finally been assessed. When CBP issues a decision about the tariffs or duties that are owed, an entry becomes liquidated, okay? However, that determination does not become final or conclusive for 180 days. So after an entry is liquidated, you have a 180-day period in which you can protest CBP's determination. And so that it's very critical to know, because in order often to get to court, you need to go through some of these administrative stages of protesting an entry if you think there's something wrong. And then with respect to IEEPA, you're going to want to file a protest for any liquidated entries that have not gone past the 180-day period. After 180 days, if no protest is filed, then liquidation becomes final and conclusive. So those are your kind of three buckets in terms of thinking about where your import or your entry lies. And we're constantly talking with our clients and making sure they understand, and you can kind of track your liquidation status in what's called ACE, the Automated Commercial Environment, which is a CBP system. And so we recommend everyone be tracking where your entries are in those three buckets, because it's going to change the kinds of things that, or the kinds of processes or documentation that you're going to need to file. So as Ben mentioned, just 2 days ago, the Court of International Trade ruled that CBP must issue refunds for unliquidated entries, that's that first bucket, and liquidated entries that are not final, which is the second bucket. It didn't really talk about liquidated entries that have reached a final and conclusive state. So there's some ambiguity there. Our understanding is there's a hearing happening today with the judge and CBP, so there may be some clarity. The judge's order did not give a timeline to CBP. It did not provide for any official mechanism to CBP, so that's all kind of to be determined. But if you have unliquidated entries, our view is there's no immediate action required. Those entries should liquidate probably on the standard timeline, and any IEEPA duties that are paid are likely to be liquidated either contemporaneously or refunded either contemporaneously with liquidation or around that time, maybe a little later. If you have entries that have liquidated but are still within the 180-day period for a protest, you need to file a protest with CBP to preserve your rights to a refund. And again, we are counseling our clients to do this because it's a way to make sure that if the government appeals the CIT's decision on issuing refunds, or if there's some delay, you still preserve your right in order to get that refund before the liquidation becomes final. For entries that are in that third bucket, where liquidation is final and conclusive, we're after the 180-day protest period, it's likely that you'll need to file a claim at the CIT in order to also preserve your rights or to get a refund. And so I think the The thing to remember is sitting back and waiting for your refund check in the mail is likely not the best strategy. But tracking your documentation, tracking your liquidation status and ACE, those are going to be critical for ensuring that you get your refund and you preserve your rights to a refund. And so some of that can be really complicated, but we've been counseling our clients to kind of file these in order to make sure that you're doing everything that you can to preserve your rights. And I'm happy to answer any specific questions you might have about what that looks like or how to do that. But that's, I think, where we stand on IEEPA refunds for now. And again, keep your eyes open because there should be some movement today or next week as well.
So a lot of you are probably thinking, great, IEEPA's done. We're done with that. We're moving on. But what's next? So as Chase said at the very beginning, the Supreme Court addressed tariffs under IEEPA. It did not address tariffs under any of the other statutory tools that the president could use. Notably, Section 232 and Section 301 have already stood up to court challenges. So we believe these are tools that the president is going to keep using and using at an increasing frequency to impose tariffs. Currently, there's a lot of Section 232. These are like the sectoral product-specific tariffs. So think of steel, aluminum, autos, truck parts, lumber, things like that. These are supposed to be in the interest of national security, but this administration has interpreted national security fairly broadly, and the administration has indicated that the sky is the limit with Section 232. There's ongoing investigations. They're open to hearing from industries, and we've been in communication with the administration on behalf of industries that are interested in, what this tool could look like to help those industries that are perhaps suffering from, the effects of unfair trade. Section 301 is another one. So there's currently completed investigations on China. There's tariffs on China under Section 301. And then Nicaragua, 10% will start in 2027. The administration has also signaled that there are several investigations planned on an accelerated timeframe under Section 301. So I think they're really going to ramp that up now that IEEPA has been declared the tariffs have been declared illegal under IEEPA. So importantly for Section 301 and Section 232, these include notice and comment periods. So I think Ben at the beginning showed you all where the docket for the critical minerals comment period is. So this is a really important way for stakeholders, regardless of what your interests are. If you have any interest in these ongoing Section 231 or 301 investigations, the administration has to seek public comment, and so this is a place where you can make your voice heard. You can ask for specific remedies. You can note concerns with proposed remedies. This is something that we're helping clients with pretty regularly, submitting comments on these dockets, and this is definitely a way to make sure that your interests are accounted for when they're making these decisions. Next is Section 122. So this is the big one that was announced right after, basically almost immediately after the Supreme Court's decision was announced. So this is supposed to address balance of payment deficits. Right now, the tariffs are 10%. Treasury Secretary Scott Bessent has indicated that these are likely to go up to 15% probably this week. Our understanding from talking with the administration is that this is almost certain. Secretary Bessent wouldn't make that claim if he wasn't aware of, pretty immediate action that's going to be taken. But for right now, it is 10% until there is actual action taken to bump it up to 15%. As Ben said at the beginning, this is limited to 150 days. So these would expire July 24th unless extended by Congress. But our understanding from talking to the administration is that the Section 122 tariffs have always intended to be a bridge after the IEEPA decision. So I think the administration is more focused in the long term on these measures that have held up to legal scrutiny. So Section 232 and 301, those seem to be more of the priority. The Section 122 tariffs are more of a bridge to get there. So I don't think the administration is counting on Congress extending the measures, and they're kind of just a stopgap until the longer administrative processes of Section 232 and 301 can kick into gear. Importantly, under Section 122, and I think this was on the tariff dashboard as well, but de minimis treatment remains suspended. So goods valued at or under $800, there's no more de minimis treatment for those. So you still have to pay duties on those goods. That was originally the legal basis for that suspension of de minimis treatment was under IEEPA, but as soon as that decision was revoked, the administration pivoted and changed the legal basis for that, and so now it's under Section 122. There are basically the same exclusions under Section 122 as there were under the IEEPA tariffs. So USMCA duty-free goods are still duty-free. There's a lot of the product-specific exemptions that I think Ben showed where the annexes were to see what those specific exemptions are. And then Section 232 doesn't stack on top of, or Section 122 doesn't stack on top of Section 232. So if you're already paying Section 232 duties on a good, then Section 122 would not stack on top of that. And we put at the bottom kind of what the stacking formula is. So you pay the base tariff, which is the MFN or FTA rate, plus any AD/CVD duties, plus Section 301, and then the Section 122 duties on top of that. Section 122, though, would not stack if Section 232 duties are paid on the entry. We also have on here some other potential future actions that we think are probably less likely, but certainly in the president's toolbox. So Section 338, which is up to 50% additional duties or block imports from countries that have discriminated against U.S. commerce. So this is another kind of not used before, but perhaps more flexible way to get broader tariffs, which the president has indicated he is interested in. We could also see IEEPA used again, but this time for licenses. This was discussed during the Supreme Court oral argument. And I think one of the arguments the administration made was, well, how can you say that global tariffs are not allowed, but we could perhaps impose a license scheme or an embargo scheme that would just prohibit all imports totally? So that is something that IEEPA would allow, but we haven't heard any indications from the administration that they're looking at that option. So all of this is to say there's a lot of tools in the administration's toolbox. They are already using some of them, and we're definitely seeing them ramp up investigations in Section 232 and 301. So the moral of the story is keep monitoring the situation. It changes every day, every week, and we expect the administration to use a lot of these tools going forward now that IEEPA is no longer an option.
So, Maggie and Chase, I just want to say briefly, thank you again. You guys were on our webinar in November in all of that chaos. And again, now to give us an update after these important decisions are taking place. And so it's great to have you here and great to have your Utah ties as well. And so just so appreciate this great advice. We did have a question in the chat about how do we file a claim in ACE. Maybe that's something we can walk through briefly.
Yeah,
Yeah,
definitely. I
so
don't know. Oh,
oh,
go
go
ahead,
ahead, Maggie.
Chase.
I think ACE is really where you're going to track your liquidation status. Filing a protest is kind of its own separate procedure, and there's a different way of doing that, not in ACE. And so that'd probably take a while, but I'm happy if you want to reach out to Maggie or myself, you can see our phone number and email there. Happy to walk you through what that protest process looks like. But ACE is where you're just going to track the liquidation status, and that will help you understand whether you need to file a protest or whether other options need to be taken.
We've set up a really streamlined process in our office. We know that this is something that, especially a lot of small businesses that aren't regularly, having to deal with these sorts of things, they don't have a ton of money to spend on lawyers, spending hours and hours on this process. So we have in-house custom brokers that have set up a really streamlined, kind of automated process for filing protests and tracking liquidation status. So if that's something anybody's interested in, we're happy to set up a call and talk about what our process is and how we could help you with that.
Great. Thank you, guys. I don't see any other questions. Any final closing thoughts, Rich, Chase, Maggie?
Tuned. Trade, we were talking on the call before, it has been a full sprint since last year in the trade world. I don't expect it to slow down anytime soon. Maggie went over a lot of the different tools. The president is still very interested in, getting trade deals with various trading partners and having leverage where he can. So this is a moving target. And so I think it's very important to just kind of keep your eye on liquidation status, keep your eye on what's happening, keep coming to these weekly webinars and stay to get informed and stay informed. But the best thing you can do is to be proactive and not just kind of sit back and let things happen.
That's great. And I do have one more question that popped in. We're going to try and address it, even though we're at time right now. Can you speculate on tactics and strategy regarding how the administration might dig in on objecting to refunds? President Trump has already alluded to years of lawsuits around this.
Mm.
Wonder if we can
Yeah.
address this as a closing point.
Yes, I think that the administration will be very litigious in contesting the refund process, but the Federal Circuit very quickly sent the decision back down to the CIT, and the CIT very quickly issued an order. And Judge Eaton was very clear he is the only judge dealing with this. Nobody else is going to be bothered with this. I don't think that the courts envision taking a long time to decide this. I think that they kind of see that a lot of people have millions of dollars of interest in this issue, and I don't think the courts want to drag their feet, but that doesn't mean that they can't be forced to drag their feet if there are multiple various lawsuits. So
Yeah. The only thing I would add is kind of what we've been talking about, right? You may not get a refund just by sitting back and letting the liquidation status happen, right? And so by requiring a protest or requiring a CIT claim, that will slow down and may actually result in just some people not wanting to go through the process, and so the refunds never have to be issued. So they can, the government may require you to jump through some hoops in order to get a refund, and in so doing limit the number of refunds they have to actually provide, because some parties may just find that it's not worth it or they don't understand it. And so, as Maggie noted, we've developed a kind of automated process to make this super easy for people, and hopefully that's a way for everyone who is owed a refund and deserves a refund can get one.
that's the ending message. There will be hoops. Anticipate hoops for sure.
Awesome. Ben and Cass and Maggie and Chase, thank you very, very much. Thanks for your expertise. And we're uncharted waters. We could say that every week, but we really now are in uncharted waters. And so, clearly there's opportunities for help from Cassidy Levy Kent. And feel free to reach out to us at World Trade Center Utah. This is an actionable time. And so if there are questions on what to do or where to go, we will help you find those answers. This is what we do. Next week at the same time, 9:30 on Friday for the next tariff webinar. Thanks everyone for joining, and we'll talk to you soon.
Thanks, everyone.